All right, so we're all set. So, hello everyone. We are going to get started because we do record these and put them on the Maine DOE YouTube page. But thank you everyone for joining our January McKinney-Vento and foster care office hours. I'm Signe Lynch. I'm the McKinney-Vento homeless education support specialist at the Maine DOE, and I will pass it over to Aubrey to introduce herself as well.
Hi, everyone. My name is Aubrey Howard. I'm also with the Maine DOE. I'm the State Education Agency foster care point of contact. So thank you for being here on the first week back from vacation in 2026.
Yes, awesome. So, and we are fortunate enough to be joined by Sarah Ferguson today. And Sarah, do you want to do just a quick introduction of yourself, and then I'll just do my quick updates and we'll pass it over to you?
That sounds like a fine plan. I am Sarah Ferguson at the Maine Department of Education Office of Special Services and Inclusive Education, and I'm the point person for um, students in state foster care or that have special education as well. And so I work closely with Aubrey about that, and I work closely with Signe because also I assign special education surrogate parents and students who don't have a parent as defined in law. Would have a surrogate parent assigned. So, and you'll learn all about that later on if you don't already know.
Yes, awesome. So we are really grateful to have Sarah today to talk about special education surrogate parents and answer questions for folks from the field. Before we turn it over to Sarah, I just had a few quick updates from Aubrey and myself, just McKinney-Vento wise, and foster care wise. So we did have some upcoming trainings to spotlight for folks. If you are not familiar with Schoolhouse Connection, they have some good offerings in the month of January. And also wanted to highlight a Maine option from Finance Authority Maine for on the 14th. So opening doors and supporting college access for homeless and foster youth. That's a good opportunity just to learn more about the FAFSA process. And next office hours in February for us is going to be with Full Plates, Full Potential. So talking about some food resources for students. And then Aubrey, did you want to just highlight your upcoming training?
Definitely. So we have our annual foster care points of contact training happening Thursday, January 29th from 3 to 4 p.m. An email went out to all the foster care points of contact, both from SAUs as well as the OCFS district points of contact. Feel free to share the slides with folks to make sure that they have this resource. There will be a lot of updates, information on Title I, educational stability provisions, and a great time for points of contact to connect.
Awesome. We have been doing, if you are registered and signed up for that McKinney-Vento and foster care newsletter that goes out monthly, we have been doing a McKinney-Vento liaison spotlight as part of that program. Most recently, we did spotlight some of the work happening in RSU 9 with our McKinney-Vento liaison, Amanda Clark. If you are a school district that's interested in being spotlighted and interviewed and having some of your program highlighted, you can certainly reach out to myself and we can get an interview scheduled. I'm just trying to get some more feedback from the field and be able to highlight some of the great work that's happening across the state. I did have a quick update on preventing student homelessness funding. So, as most people are familiar with, this is a state program that was a 2-year pilot program that provided funding for all of our SAUs through a formula grant. And in the most recent legislative session that ended over the summer, that program was made into a permanent program, and the fiscal note was changed in that bill. So it was from a reduction of funding from 1.5 million, which would have been the continuation of that funding line. And it was reduced to 125,000. So a significant reduction of funding that made it very, very difficult to do a formula grant essentially. So we did work through that FY26 funding, that 125,000, and there will be a new allocation. So if you are a school that an SAU that participated in the FY25 funding application, you will receive an additional allocation in the coming next few days, and it will kick your grants for me funding application into revision started. So you will just have a small additional allocation available. It will still have the same obligation of March 31st because it's going to be a small amount of funding for those participating SAUs. So there's a base amount of $200 that will go out to all of those participating SAUs within that. And then we did do a weight per McKinney-Vento student identified for that October 1 count. So more information will go out once that funding is available, but that has been cleared through our finance team. So we are just waiting to have that uploaded into Grants for Me. So just anticipate some communications in the coming days of just additional, that small additional allocation that's available in that application and Grants for Me. And then Aubrey, did you want to
Yeah,
update for OCFS?
definitely. So our OCFS foster care points of contact list has been updated. There's been a few new changes for different districts. We'll be highlighting this again in our annual training, as well as our NEO contact list was updated a couple months ago. So that should have all of the current updated SAU foster care points of contact. We are currently working with some of our data team members to do a similar, how the McKinney-Vento liaison lookup is on the McKinney-Vento website. We're doing a similar one for foster care points of contact to make it more accessible for folks to figure out who their points of contact are. So hopefully that is uploaded by end of February, beginning of March. And if you have any questions or need support with contacting and reaching out to your foster care points of contact, you can always loop me into those conversations.
And I think with that, this is just our general resources and links to our web pages and includes our special education surrogate parent links for Sarah Ferguson's information. And with that, I will turn it over to Sarah. And before I do turn it over, I did want to see if anyone had any questions about any of those brief updates that we had. All right. All right, so I'm gonna stop sharing my screen and let Sarah take over.
All right, thank you. Let me make sure I'm going to share the right screen. I think that's the one that we want. Um, yeah, well, thanks for having me. We are all very lucky to have Aubrey and Signe working with you folks, and we are very lucky to, of course, have you folks out there in the field working with these kiddos who need extra support, kiddos and families that need extra support. So they asked for me to come and talk about special education and McKinney-Vento and foster care. And now I need to find the right buttons. Somebody earlier said moving back and forth between Google Meets and Zoom is difficult, and I agree. So this is the DOE mission that you folks can read. I don't need to read it to you. And the department's strategic goals. You can get this PowerPoint afterwards. And so we're going to talk about individualized education programs and free and appropriate public education, also known as FAPE. We're going to talk about state agency clients, and we're going to talk about special education surrogate parents. So the first idea that we want to talk about is that all students are general education students first. So when a student with special ed is people are talking about having IEP team meetings or, which district they should enroll in, then we make sure that people understand that that's a general education process. The best interest determination is a gen ed process. We also understand that sometimes special ed directors wear the hat of the McKinney-Vento liaison or of the foster care point of contact. So sometimes it can get all kind of rolled up into one. Um, but we just want to make sure that everyone understands that the general ed process, um, you would have the bid and then you would determine into which SAU the student would enroll. And then if a student receives special education, then you would hold an IEP meeting if the student changes where they're going. This is a sample bid document this is for foster care students. Am I right, Aubrey? This is the foster care sample bid document.
Yes, there
And
are a few forms on our website, and I'll post the link in the chat.
Um, thanks. And also, so not only on Aubrey's foster care website, but also on Signy's McKinney-Vento website. Um, oh, here is a state rule of Chapter 14, which, help me, is this McKinney-Vento Chapter
Yes,
14?
chapter
Okay,
14 is, yep, McKinney-Vento. So this is just highlighting Aubrey's is the bid forms are on the foster care site. And then really for McKinney-Vento, it's looking at that chapter 14 and the best interest determination section within it.
thank you. So this is the front page of what we would look at for an individualized education plan, an IEP. Um, to be eligible for special ed, a student must have a disability, but also must have an adverse effect to their education. So a student may come to you with some medical diagnoses or some such thing, but if there is no documented adverse effect, they would not be eligible for special education. This is what Maine Unified Special Education Regulations we call MUSER talks about with children who transfer school districts. So in general, IEPs for children who transfer SAUs within the same state. If a child with a disability who had an IEP that was in effect in a previous SAU in the same state transfers to a new SAU in the same state and enrolls in a new school within the same school year, the new SAU, in consultation with the parents, must provide free and appropriate public education to the child, including services comparable to those described in the child's IEP from the previous SAU, until the new SAU either adopts the child's IEP from the previous or develops, adopts, and implements a new IEP. So what this is saying is that if a child comes into your district and enrolls in your district, the IEP that they had before remains in place until there would be an IEP meeting. Any questions? Check in. Everybody doing okay? If you would like to ask a question, please unmute. I appreciate and I like to talk about things at the time so that and you don't have to hold and ask any questions at the end. Okay. This is an infographic that we have that talks about who is responsible for a student's education, because that's a lot of what questions we have. So if the student lives with their parent or guardian, then it's the SAU has the responsibility where they live, unless, of course, they are McKinney-Vento eligible, which is purple in the center there. So if a student lives with their parent or guardian, then the SAU where they live is responsible. If a student is placed outside of the state of Maine in a residential treatment through the Office of Behavioral Health process, then the SAU where their parent resides remains responsible. And so this sometimes gets confusing because DHHS has many arms. And when we're talking about kids in foster care, we're talking about kids whose case managers are through the Office of Child and Family Services or Child Protective Services that we call them. This process that we're talking about, if you're placed in a residential treatment through the DHHS process, that those caseworkers or program coordinators work for the Office of Behavioral Health. arm. So the parent retains custody, but sometimes the parents ask the Office of Behavioral Health for help in finding residential treatment for their students. If a student's hospitalized or at a crisis stabilization unit, then it's where the SAU, where their parent or guardian resides, or if they are detained at Long Creek. In the green side, where the student resides, if they are placed in Maine in a residential treatment through the DHHS process, then the place where the residential treatment is their SAU. If a student's in a foster care home, then they are where they reside as long as that was their best interest determination. An adult student, their SAU responsible is where they reside. And when a student is placed out of state in a residential treatment facility and is in foster care, their last SAU that had them keeps them while they're out of state. And then there are other factors in the purple. If you are committed to Long Creek Developmental Center, then you attend A.R. Gould School, which is inside of Long Creek. If you're experiencing homelessness, you would stay at your school of origin unless the bid determined otherwise. And if you're in foster care, the same. You would stay at the school of origin unless your bid determined otherwise. Here's another infographic we have for what we call a state agency client. And I think that this gets confused out there as well. The the reason behind having a term called state agency client, and Maine is the only state that has this term, is that the Department of Education is fiscally responsible for special education costs for state agency clients. If you look in the center circles, all of these say that the student has an IEP. So in order to be a state agency client, you have to have an IEP. And so students who are in DHHS custody and also 6 months after reunification with the family, they remain a state agency client. And so DOE is responsible for their special education costs. If a student's adopted, then it ends immediately. So this is only for reunification. If a student's in parent custody and is placed, like we were talking about, those residential treatment centers with a non-relative guardian for non-educational reasons and has an IEP. So any student who is placed in a residential treatment facility through the DHHS process and has an IEP is a state agency client. If you're in the custody or under the supervision of the Department of Corrections, that's our blue circle, and you have an IEP. The red circle is attending school while a resident of a state institution. At the moment, we don't have institutions, but it's still part of our regulations. And adult students who participate in V9 or are in Section 21 or 29 with DHHS and have an IEP are also state agency clients. So that was a lot of information about some of our acronyms. Any questions here?
Is it super relevant what the V9 and that last one was? I don't.
Well, what a V9 is, it is an agreement that a student who's in foster care makes with DHHS to like continue support through DHHS for kids who age out of foster care.
Okay.
So thanks for asking. Yes, it is
Thank
super
you.
relevant because if you have kids who are 18 or 19 years old in foster care, then or who had been in foster care, yep. Thanks for asking. Did I see somebody else's hand up, or was that the same question?
I was just wanted to ask a question. I have a situation right now where a kid has been, who is in foster care in DHHS custody, has been, moved pretty frequently throughout the state. At what point do we look at a best interest determination meeting when the transportation, like, I don't know if this is an in-depth conversation more after this, but, when the transportation is exceeding, an hour and a half each way and it's multiple locations, like, because I feel like even if we had a best interest determination meeting, DHHS has the final say and will tell us that we keep him anyway, the student. But at what point does, is it always at the end the DHHS has that final say, or?
So, I heard you say, when do we have a best interest determination meeting and the kid's moving? I think the answer is you have one every time the kids moves. And I'm going to let Aubrey speak to the process.
And I think that's a great question and one that definitely comes up in the field. So thanks for bringing that up. I would say, so as Sarah mentioned, a best interest determination meeting happens when a student enters the child welfare system or when there's a placement change. So that's a process that can happen when one of those two circumstances happen, or if perhaps there's a planned placement that will be
So
happening. And yeah, go ahead.
each placement is another hotel. So it's just moving from hotel to hotel to hotel. So it's not actually like a placement. And that's what's hard. So I haven't had a best interest because, the student isn't in a foster care placement. It's just another hotel that has been moved. So would we have it even though like they're staying in a motel in a different town, like each place that they move this student to? It just doesn't feel like, we would have any ground to stand on of the best interest is to transfer the student as far as McKinney-Vento goes when they're not even in, a place that they're going to reside long term. But then it also doesn't feel right that we're just constantly moving this, student around throughout the state and saying that the best interest is to continue doing this.
Definitely. And I think that could also be considered if if a student was moving from foster home to foster home, a hotel to a hotel is a placement change for that youth. And so I would say bringing folks together at the table to have that conversation, to just identify what is going on, what people do we need to have at the table for that, what are some of the scenarios and the situations, is this long term, is this just a quick hotel transfer, like what is going on? And so I think bringing people to the table to have that conversation is really important. And then you could identify from there, what does this best interest determination meeting look like? And a key goal of those meetings is for it to be collaborative between OCFS and the SAUs. And so the hope is the dispute, it doesn't just automatically grant OCFS the right to make that final decision. The goal is to have that collaborative conversation, to have all voices be heard at that table. And if throughout that collaboration, there isn't an end final decision that is agreed upon, then currently DHHS does hold that final decision making. But the hope is collaborate before that.
I've been working in schools for over 30 years, and I know that I'm in the middle of sort of a very rural part of the state. But for the other folks that are on the call, have you ever been involved in that type of a meeting? Because I have never been invited to a determination meeting on where a kid is going to be placed. Anybody?
I've requested it a few times with DHHS, but what I've determined is that they make the decision anyway, even if I, bring everyone to the table and voice concerns. They do what's best, I feel like, for, unfortunately, sometimes the department, and not necessarily the child.
And I, where I am, it's very difficult to find placements for kids, and I understand that. I just was curious because I've never had that experience in all my years.
I had one. I've only been doing the foster care thing for like a year and a half, and we had one for a student coming out of Long Creek. It was very confusing, however, because the registration that they did was from the Gould School, and so the folks at my high school didn't know what the Gould School was. They mistook it for the private school in Bethel, and the person who was working at Long Creek to do the transfer just got really angry and thought we weren't doing what we're supposed to do. So it was very complicated, and I'm not sure they really knew what the purpose of the meeting was either. So, but that, I mean, again, I haven't been doing it that long, but that's the only one that I've done.
Thanks.
Yeah, and I think that brings up like great questions about the process. And I know Sydney, myself, and Sarah are about to embark on a OCFS roadshow where we'll be going to each of the different district offices to talk about the Title I, Part A educational stability provisions, highlighting the key point of collaboration, as well as best interest determination meetings. So we're continuing to give this training to the field. If you ever need support with those conversations, you can always loop myself in to help advocate for a best interest determination meeting or support along the process for educational stability.
Right. And I think so much of the foster care provisions that Aubrey and Sarah are speaking to really come out of Every Student Succeeds Act in 2015. So there was really those amendments that clarified all of these pieces for foster care. And even when we're looking at, school policies related to McKinney-Vento, we still see, in that definition of awaiting foster care placement in a lot of schools' definitions for students that qualify for McKinney-Vento, which it was for so long prior to 2015 and Every Student Succeeds Act. So it really is just trying to update and clarify what these foster care provisions are and helping build that bridge with OCFS as well. So, yeah. Yep. So I think it's an ongoing journey that we are on at the DOE and in collaboration with OCFS. And I think just also from schools' perspective, if you're the foster care point of contact, you're working with these students, really just consistently requesting for that meeting as well. And then we'll continue to do our end of just working with OCFS and providing that education and training. And we're also happy to provide some education and training for your staff as well.
Thank you. Great questions. And all right, I think this is the right screen to get back to. And we absolutely appreciate the questions, like we said. So now I'm going to start talking about special education surrogate parents. And so we think about it's a very small amount of students who are in foster care or our state wards that need a special education surrogate parent. So there are upwards of 2,000 or 3,000 students who are in child welfare custody. And then there is a subsection of those who are also in special education. And of those, most of them are placed in a foster home, and the foster parent will hold the special education rights. They are in the definition of parent in both the Individuals with Disabilities Education Act, as well as in Maine Unified Special Education Regulations. So they do not need to be appointed as surrogate parents. There are a very small number of students who have an IEP, and they're placed in a residential setting that is not a foster home, such as most often residential treatment facilities, or the Gould School because they're in Long Creek and they would need a special education surrogate parent.
Can I ask a question about that?
Yes, please.
So we have a student that was just released from Long Creek.
Mm-hmm.
So she's 18 and was placed in an adult residential home. So our question is, does she need a surrogate parent or is she her own guardian?
So she would be her own guardian unless the judge deemed otherwise.
Okay.
Yep.
Well, I have a question.
Sure.
Again, we had a different issue, but on this topic. So when a student is in DHHS custody, has foster parents,
Mm-hmm.
and DHHS is the guardian.
Yep.
Do the foster care parents can they still serve as the parent in the IEP? Does it have to be spelled out if they're not actually declared in the document we get the guardian?
So they do not have to be declared in the document. And so a little further along, we'll talk about
Okay,
the split uh, between responsibilities. So the
right.
DHHS guardian is going to hold all general education responsibilities, and the DHHS guardian has the responsibility to enroll students in school and sign field trip forms. Now, whatever outside of education law, whatever agreement DHHS has with the foster parents, and maybe DHHS is saying, well, you're now the foster parent, so you now can sign the field trip permission slips. So that's outside of DOE, it's outside of special education purview, right? Because that's general education things. And I know that when I was in the classroom, I actually had no idea that it was this foster parent who held the special education rights. So anything that comes out of a special education office, by law, federal and state law, is the foster parents hold the rights to, sign for consent, sign for initial placement, sign that the IEP, that they agree to the well, they don't sign, but be part of the IEP team and agree to the IEP.
Sarah,
Some,
can I just ask a
yes,
question real quick?
sure, please.
So if it is the foster care parent, and I'm not saying this happens all the time, but
Hmm.
if the foster care parent in a team meeting
Hmm.
disagrees with the DHHS caseworker,
Hmm.
is what you're saying that the foster care parent, um,
The foster parent holds parental rights.
okay, thank you.
Yep. Uh, DHHS case managers are invited members to the IEP team, so they are a part of the team, but ultimately the foster parent holds parental rights. Yep. So this is the definition from Maine Unified Special Education Regulations that is the same as from Individuals with Disabilities Education Act, IDEA. Um, so a parent would be the biological or adoptive parent or a foster parent, a guardian generally authorized to act as child parent. And so the law specifically states, not the state, if the child is a ward of the state. I actually unfortunately, had a state DHHS guardian reach out to me and say, the district is telling me I have to sign the special ed paperwork. Would you please let them know that it's not me, that we need to assign a surrogate parent? Because as I said, when I was in the classroom, I hadn't I hadn't become aware of this piece of the law. So I didn't know. Um, and then D also sometimes, people call and say, well, what about the grandmother that this homeless student is living with? Then it's an unaccompanied homeless youth, and they're living with grandma. And I say, well, the school can decide if that grandma fits underneath D, an individual acting in the place of a biological or adoptive parent, including a grandparent, step parent, or other relative. So sometimes the school determines that grandma could fit in that definition of parent for special education only. And then E is I also appoint the surrogate parents if we need them. Oftentimes, maybe a friend or a McKinney-Vento caregiver, who they're living with under McKinney-Vento might volunteer to do it. We also have a list of volunteers. Here's the IEP team membership that I talked about. So the child parents and no less than one regular ed teacher. If a student's in regular ed environment, so I mean, if a student's attending a special purpose private school or is not attending any regular ed, you don't need a regular ed teacher. No less than one special ed teacher and providers, representative of the school administrative unit who understands what's going on, knows about the gen ed curriculum, and knows about the resources in the school. The parent or the agency could invite other individuals. Always need to have someone who can interpret instructional implications of evaluation results. The child, and then here is where we were talking about before for a child who is a state ward or a state agency client, the child's caseworker representing the youth serving agency. It also here again says that the surrogate parent retains the sole authority to represent the child by exercising the procedural safeguards available under this rule, which means that the DHHS guardian is invited, but the surrogate parent holds parental rights. For students who are under McKinney-Vento, it's the same situation. There's a lot of students, unfortunately, who are homeless, and a subsection of those are unaccompanied homeless youth, which means that they are not in the physical custody of their parent. And then a subsection of those are students who would be unaccompanied homeless youth and have an IEP, which means that they're receiving special education services. So, I mean, if we think about a family who lost their house in a flood and mom and dad went to go live with Aunt Susie and the kids went to go live with Uncle Bill, the kids would be technically unaccompanied homeless youth. However, mom and dad are still highly involved, and so they wouldn't need an appointed surrogate parent because the parent is there. So we do have that flexibility to determine if a surrogate parent is needed or not. We don't always have to. If the parent is there and available and willing to be part, then we don't have to assign one. So special ed surrogate parents are appointed when a student is either already receiving special ed or is in referral. And if a parent cannot be identified or located, if a student is a state ward, or if a student is an unaccompanied homeless youth. I'm just checking my notes and I think that I've said everything already in the notes, so that's great. This is the infographic that we share when I assign a surrogate parent or when there are any questions, because this is what I think Ruth Ann was asking about, and it delineates between gen ed rights and special ed rights. So I try and get this widely known. And again, we're going to share this when we go to the OCFS offices, so that DHHS workers who their job is to make sure that children are safe and alive and don't always know the intricacies of education law. So we share it with them. This is an infographic that we have about whose job it is to worry about assigning a special education surrogate parent. So the public agency has to make sure that this children's rights are protected. So I hear from both schools and from DHHS guardians. Sometimes I hear from guardian ad litems, and anyone can ask. I always make sure that everyone who's involved in the student understands that there's been a request for a surrogate parent, and always ask if anyone who knows the student might know someone who might want to volunteer. So that it's my job to determine whether a child needs a surrogate parent and to assign it. And also it's my job to make sure it happens not more than 30 days after a request has been made. It's the school administrative unit's job to let us know if they can't get in touch with the parent, or if they can't locate the parent, they can't identify the parent. It's their job to let us know if the child's a ward of the state, and it's their job to let us know if they are an unaccompanied homeless youth. And then the surrogate parent, their responsibilities are to represent the child in all matters related to identification, evaluation, and educational placement of the child and the provision of free and appropriate public education. Those two infographics we just looked at come from This Is the Law, the actual law. So all of that information can be found in here. There is one caveat for unaccompanied homeless youth about who can be your surrogate parent. Generally, a surrogate parent cannot work for an agency that already serves the youth or family. However, if you are unaccompanied homeless youth and you are in a emergency shelter, then a staff from the emergency shelter can come to your IEP meetings and represent you until another surrogate parent is appointed that doesn't work for an agency that already serves you. So the request for the appointment can be found at this webpage, and that's my email and my phone number. When we do, this is a copy of the request to have it be filled out for information. On the back, there is a section. If somebody knows someone who might want to volunteer, they can make a recommendation, and I can follow up with that. When we do assign a surrogate parent, we do ask that their name go in the parent guardian section of all of special education paperwork. Sometimes, unfortunately, when kiddos move around a lot, like our kiddos do, the name of the surrogate parent kind of gets lost. So if it's written in all of the special education paperwork, then the next SAU could know that there was a surrogate parent assigned. And if a student is moving from a place where they need a surrogate parent into a foster care home, then the foster care parents could take over. Also, the surrogate parent might stay on for a little bit to make sure the transition is smooth. Natasha?
Would you recommend I have a student situation that's in outplacement that I talked to earlier today that has been moved multiple times? This is a different student. And would you recommend, or I just talked to them today about getting a surrogate parent for them since DHHS I guess isn't they're available but as far as like instead of a foster care placement, like it's another situation they've been moved from multiple foster care. So instead, like would you recommend if a kiddo is being moved multiple times to have a foster care surrogate instead of the foster care parent?
So if the student has special education,
Mhm.
yeah, your
Yes,
student does? Okay.
they're outplaced. Yeah.
Okay.
But I feel like there's been so
Oh,
many
that's what you
foster
meant by
care
outplaced? Yeah.
parents. Yeah,
Okay.
they're outplaced. Sorry,
Okay.
they're
No, that's
special
okay.
education
Yeah,
outplaced.
sure.
But there are our
Yes,
students.
they've moved
But they've
around.
been just moved around so many different foster
Uh-huh.
care parents, and so it's hard to get like the next IP meeting
Yeah.
is coming up, and so we're just trying to figure out like, obviously the department can act as the guardian, but I
No,
just feel like there's nobody gonna be
I'm
advocating.
sorry, but the Department of Health and Human Services cannot agree to an IEP meeting. They do not hold that parental
So if there's
responsibility.
no kiddo so if the child is in the motel with the
Hmm.
department and there's
Then
no
they
foster care placement, get a
then
surrogate.
then you have to have a surrogate. Yes.
Yeah.
Yes. Yep. Because DHHS guardians do not hold the parental authority to agree to hold an IEP meeting. Yep. And so your question about kiddos who hop around a lot in and out of foster care, temporary foster care, would I recommend a special education surrogate parent? I can't recommend, but I can say that it is in the student's interest to have someone stable at their IEP meetings who knew them when they were at this district and know them while they're at this district. And so, like I was saying before, sometimes if a student has a surrogate parent assigned and moves into a foster placement, the surrogate parent stays on. When people ask me that question, I say it's the IEP team decision, but it is a possibility. Yeah. So if you do have a kiddo with an IEP who's living in a hotel, then they do need a surrogate parent. Thanks for asking. So then we also ask everyone if it's known that someone with a surrogate parent is moving to a new district, please be sure that the new school has that contact information. This is also a form that I send out when I am assigning surrogate parents that just kind of is a synopsis of surrogate parent rights and responsibilities. One question that a lot of them have is, what responsibility do I have? Like, should the student go out and break a law? And the answer is you have no responsibility at all. The only responsibility that you have is to, um, you know, be part of the IEP team and determine what their programming should be. Um, they should, in order to do that, you should know the student and you should be at all of the meetings and ensure their confidentiality and um, carry out the duties of the surrogate parents and, keep your records and let DOE know if you think that there's a conflict of interest. But your responsibilities are limited and you have no authority or responsibility for the care, maintenance, or financial support of the student. And the surrogate parent could talk with other agencies about things like selecting a foster home or a group home placement, but they have no authority or responsibility to approve any non-educational placement. Any other questions?
And Sarah, I just wanted to clarify. So if you are working with a student in school that is in like Natasha's situation, where it's a foster care student that's bouncing from hotel to hotel, they don't have stability in an adult caregiver at that time, or for example, unaccompanied homeless youth that might be couch surfing in potentially unsafe situations, and the special education team doesn't feel comfortable saying that the caregiver that they're temporarily residing with is someone that could make a decision for special education. When they go, and if there's not someone that they can recommend, your list is people with expertise in special education.
Yes.
Correct? Yep.
Mm-hmm. Yes, thank you for that. Yep. And a lot of the people on the list are retired special ed directors. Actually, there are some active special ed directors who can be a surrogate parent, just not for students who are in their SAU. We have some school psychologists, speech and language pathologists, people who have worked within special education are most of the volunteers that are on our list. Actually, we have a couple that are foster parents. And so they've been, through the process with some of their other foster kids, and they are surrogate parents for kiddos outside of their outside of their area, because now that we have Zoom, it doesn't really matter where you live to attend a meeting, which is wonderful. I also want to make people, just say this, that yes, our volunteers have special ed expertise. However, it is the job of the school to let parents know about what their rights are. And if you are a parent of a child who needs special ed and your 5 or 6 or 7-year-old is going to school, and if you determine that there's a disability that has an adverse effect, then you as a new parent aren't going to understand all the ins and outs and intricacies either. So it's also the school's job to help walk parents through all those processes, and make sure that everybody's rights are being upheld. So even if I don't want people to think that if they have someone to recommend that they have to be an expert in special ed, but we are also very lucky to have volunteers who are. And that was the end of I don't know, I don't think I need to share my last slide that has my name and contact information in it, because it was shared a little bit ago, and that was it. So thanks for having me, and thanks for asking questions.
And can I just ask one more clarifying question, just because it's
Always.
come up before? So if a school has an unaccompanied homeless youth that may, for example, be living with another relative that's not their legal guardian, they may be acting as a parent under FERPA, they might be in communication with the school, but there may have been a series of incidents or interactions that may make the school feel hesitant to appoint them as a special education surrogate parent. But that family member might be saying, I really want to be there. I want to be the IEP decision making. Is it really the school that could make that decision about a special education surrogate parent being appointed if they have advocacy from someone who is acting as a caregiver? I just wanted to throw that out there.
Yeah, thanks. So like we were saying before, always give me these thinkers, Signe. Come on. As we were saying before, we do have latitude. Anyone who is an unaccompanied homeless youth has the right to have a surrogate parent, but there is latitude to decide whether or not they need one. So, and IEP things, this is education law. So it is up to the schools to let me know if someone needs a surrogate parent. So if somebody called and said, they have this person that they're staying with, but they're not responsive to school, they're not, answering phone calls, they're not, and we would like to have a surrogate parent, then that's who I would go with because it's up to the public agency to make sure that the student is being represented. So yeah.
Thank you.
I had to fill in a little bit there, give myself time to think about that one. Any other comments, questions? We have a couple of minutes. I don't know, any situations you folks want to share that other people might learn from or?
Yeah. Does anyone have any questions about the special education piece? Otherwise, I'm going to stop the recording. But if anyone has any other. All right, I think I'm going to stop the recording. Thank you, Sarah.
Thanks.